talking once she starts talking, because this opening is really great.
Good. All right.
All right.
And if we could, if everybody could go into the back, who's up here, so that these seats are free for people who are taking the shuttle over later. All right.
I'm just going to start by reading a cautionary statement that was made by actually the North Carolina Supreme Court with respect to guardian ad litem appointments, but it seems particularly apt as a way to frame this training today. So, many a man has prosecuted a lawsuit to his detriment or ruin. His ordinary caution and good judgment warped by prejudice, spite, or a stubborn purpose to vindicate, quote, the principle of the thing. His attorneys in the court may have been entirely convinced that he was blindly and contumaciously refusing to settle his case upon terms which were obviously advantageous to him. And they may have been right. Yet, quote, no man shall be interfered with in his personal or property rights by the government under the exercise of its parental authority until the actual and positive necessity therefore is shown to exist, end quote. We have found no completely satisfactory definition of the phrase, quote, incompetent from want of understanding to manage his own affairs, end quote. Furthermore, we do not believe it is possible to frame a definition which will include every aberration which might produce the incompetency to which reference is made. The facts in every case will be different, and competency or incompetency will depend on the individual's general frame and habit of mind. Mere weakness of mind will not be sufficient to put a person among those who are incompetent to manage their own affairs. That's what I want you guys to think about as we continue on in this training.
And I'm really excited to be doing this training because this may be the most important training we've ever given. Because we are almost all ignorant. Even I, at the beginning of learning about this subject, was completely ignorant. I had so many wrong ideas. I've been doing it wrong for so many years. So I just wanted to give you a hint. Back in the panel days, which you all hear about, but very few of you were there, back in the panel days, the truth is that the guardian ad litem was one more person who got paid $450. So nobody ever thought twice about having a guardian ad litem appointed for their client. They really, most people, I'm sure that Mr. Krikorian here, never inappropriately accepted appointment as a guardian ad litem. Never. But many people did, and I was one of them. And, you know, now I did happen to do a really good job once I got appointed to that job, but it was real weird because a guardian ad litem is not a lawyer. I think that's probably the first step to really understand. Does anybody know what the current, for a $5 Starbucks card, does anybody know what the current rule of professional conduct is governing the duties of a guardian ad litem or the duties of an attorney in seeking the appointment of a guardian ad litem? The current rule of professional conduct in California. Has anyone got it? Okay, let me try this. It's a trick question. What? There isn't one. Awesome. There isn't one. Can you imagine? There is case law, and all the case law is a little bit subtly different. And that's all we have. Except for... Okay, go away. Oh.
All right, so the definition of when would you even think that a guardian ad litem may be triggered, or the need to request the appointment of a guardian ad litem may be triggered. Currently, case law says that it's determined by incompetence or competency, and to determine competency, case law directs us to a various number of different codes, including probate code, section 1801, penal code 1367, and code of civil procedure 372, which y'all have in your, sorry, I said y'all, have in your materials on the cheat sheet. Basically what it boils down to is whether or not the parent has the capacity, number one, to understand the nature or consequences of the proceeding, and number two, to assist counsel in preparing the case. And before Mr. Smeal goes on with that, I did want to really, really quickly indicate to you that This is from In Re Joanne E., which is also part of your case law summary materials, where the court in that case indicates, just as I said, the two standards. But what it is important to know is it is not whether the individual is difficult to handle as a participant in the process. Far too many times we're dealing with difficult individuals and they are inappropriately being appointed guardian ad litem.
And I think that's what really inspired this training in the first place, was my seeing in courtroom after courtroom guardian ad litems being appointed for a client who was just difficult. Irascibility is not incompetence. Irascibility is something that a good lawyer has to deal with. You do your client a fatal disservice if you get them a guardian ad litem appointed just because you're having difficulty communicating with them. Does anyone have a client who has a guardian ad litem or is a guardian ad litem for a client who got their kid back, who reunified with their child? Does anybody have a story about that?
Jennifer Bryan does, and there's a kid.
Was Jennifer Bryan tell the story?
Well, I have a mouthful of food, but that's not true.
I didn't think it was. Well, that's okay. You can tell the story later. There's going to be a section, and you'll be able to earn a $5 Starbucks card for telling us your story. But right now, I wanted to tell you about what the proposed rule of professional conduct is. Right now, before the Supreme Court of the state of California is a proposed rule of professional conduct that states as follows. And there's also, this is also on your proposed ladle or rather yours says ladle GAL policy. And it has now been approved by our esteemed leader, and this is what we're operating under until further notice. I fully expect that we'll be revising it as time goes by. And if you've got ideas on it about changing it, please come and see either Jessica or I.
Just to clarify, the ladle policy is not a direct reiteration of the proposed rule of professional responsibility. It's sort of our creation with Ken's input as to what our policy should be given all of the case law, proposed rule, and information out there.
Because remember, the rule of professional conduct doesn't specifically apply to dependency court. And we're trying to, what we've given you does apply to us. When a client's capacity to make adequately considered decisions in connection with a representation is diminished because of mental impairment or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal lawyer-client relationship with the client. That's the rule. That's the beginning of the rule. So you have to do everything that you can to create as normal as possible of an attorney-client relationship. And only if you completely fail in that procedure does anything else happen after that. I just want to reiterate these words here. Understanding that taking unsought protective action impairs the trust relationship between clients and lawyers. So it really is a shot at your client in the leg if you get a guardian ad litem appointed for them. Therefore, this is something you need to consult with them about, and you need to, well, is Sue Dell here? Is Sue Dell available by phone? Okay. Just this morning, Sue Dell called, and she says she's got a client, and actually, now I can't talk about that. I need to not identify the lawyer. Because we do have to preserve our client's confidentiality. That's one other story I wanted to tell you, was you never want to be in a situation where you're asking for unmonitored visits for your client, and the county counsel says, this guy can't have unmonitored visits, he's crazy. And you say, crazy, where'd you get that idea? And the county counsel says, you told me. You told me every time he came, you walked out there and you came back into the attorney room and complained about what a jerk he was, how he was uncontrollable, and how he was crazy. You don't ever want that to happen to you. Now, I know we work in this environment where we all talk, we come right back into that attorney room after having some horrible conversations with our clients, but you got to keep it zipped. You know, you got to call your supervisor, call your firm director, Talk to somebody else in your firm about it. There are places that you can go and people you can talk to. It's just not the other attorneys in that courtroom. Absolutely not under any circumstances. That is a breach of the duty of confidentiality. Do we do that? You want to do that on this? Okay. So, okay. Again, if you reasonably believe that your client has significantly diminished capacity such that they are unable to understand and make adequately considered decisions regarding the dependency case, and so this is kind of like a nexus thing. It's like you have to have that significant diminished capacity, but then also there has to be a risk of harm to the client because the client can't act in his or her own best interest. So it's like making a nexus argument. You've got to have both prongs of that. If that happens, then you can go to the next step, which is to explain a guardian ad litem to your client and obtain consent.
So, just to essentially indicate, we're not trying to change the current existence of case law or statutory authority right now. We're just saying that it goes one step further beyond determining that you think your client is incompetent or has some diminished capacity. The second step to your analysis is really, and is there no reasonable means to protect this client, essentially? And why is this so important? Well, that's really the whole ethics portion of this training. And sorry, I don't want to misquote the ethics portion, and I seem to have misplaced my outline, which was just right here. Okay, thank you. So, what are your ethical considerations, and why do we think that this is such a big problem? And frankly, why did the rule committee decide that a rule probably needed to be proposed on this? Because we have a couple of duties as attorneys. We have our duty of confidentiality, which Dennis just talked about. We also have a duty of loyalty. But then, in these cases where we have a potentially diminished capacity client, a potentially incompetent client, we have a conflicting duty of diligence and competency that we're struggling with in how do I represent this person when I know them to really not be understanding these proceedings, but it would potentially put me in a place where I'm violating my duty of confidentiality and loyalty to my client to alert the court or any counsel to this issue. That is where we're faced with this dilemma and the problem we're trying to solve for you guys. And that's where what really led to us coming up with this policy and following with the proposed rule of ethics. So just note and understand that everybody knows your duty of confidentiality. I'm pretty sure I don't need to go into that for you. And that duty of confidentiality, by the way, if you do get appointed as a guardian ad litem, extends to a guardian ad litem. Guardian ad litem should not be sharing any information that would be confidential. Likewise,
And I just want to be clear about that. That's what I'm talking about. That is your duty of confidentiality. When you go into the attorney room and you talk, my client is such an asshole, that's breaching the duty of confidentiality. I know it's practically impossible to feel like, what, I can't say that ever? But it is a breach of your duty of confidentiality. Sorry.
no, it's fine. Then your duty of loyalty. Duty of loyalty, really in a lawyer-client relationship, is you want to allow the client to determine the objectives of their representation and seek to achieve them. If you're asking for someone to be placed on the case as a guardian ad litem, you are essentially saying you no longer get to determine the objectives of this case, and you no longer are determining how we're going to achieve them. So you, again, put yourself in direct conflict with the duty of loyalty. The issue that we have, and I'm sure y'all are questioning, is what do I do with the duty of diligence and competence? When I know that my client is not able to understand these proceedings, I'm doing my best to maintain this attorney-client relationship, but I'm feeling really uncomfortable with going forward and being put in a place where maybe I'm having to make decisions on behalf of my client when that's not our role as attorneys. We should not be making decisions for our clients. We provide them with the information and the knowledge necessary for them to be able to make an informed decision on their own behalf. So the duty of diligence and competence that we're going off of is Rule 3-110 that states that a member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. And for purposes of this rule, competence in any legal service shall mean to apply the number 1, diligence, number 2, learning and skill, and number 3, mental, emotional, and physical ability reasonably necessary for the performance of such service. We're hoping to provide you with some more information today about how to deal with those questionable cases where you feel as if maybe a guardian ad litem is necessary, but really it's just a lot about understanding what mental illness is, the perhaps the time changing nature of certain conditions, that it's not a permanent condition, that one day they may come to court and be a little out of it, but maybe medication or giving them a cooling off period is going to result in them having a better opportunity to assist you in the defense. And I think that's
What else?
kind of a nice
yeah.
segue into your
Other
materials.
things that you can do with your client, you can first of all see if they've got any family members who came with them. You can then, again, without breaching your client's confidentiality, so you're not giving them information, although they probably have it all already if they live with these people or know them. But without giving them information, you're trying to obtain information. You can be totally upfront, because they'll come to you, they'll say, oh, but we have all these questions. I'm sorry, but I owe my duty of confidentiality to my client. I need to get information from you. I know it feels really unfair, but I have to get information from you, and I can't give you any in return. And then you ask them, is this person on meds? Maybe, yes, they were on meds, but they're broke, and they just ran out of their meds, and we're going to go straight from court today to pick up more meds. Ah, what does that tell you? That tells you that whatever you're seeing today might well be rectified by next session. So you just tell the judge, Your Honor, I need a continuance. You don't explain why. You could say my client's not feeling well, or my client's under the weather today and not capable of proceeding with the case. You should be able to get a continuance at least once. And then you send them off. You tell the family how important it is that the client gets their meds and comes back the next time, hopefully, and better able to assist in their own defense. And then you just get the continuance. Yes, ma'am.
If the court is not inclined to grant you your continuance in that instance, do you then have a duty to make the GAL inquiry? And then as a subsection to that, if the court does appoint a GAL at that hearing, is the court not under an obligation, or are you not under an obligation to have that inquiry in the future if circumstances change?
Okay, so you raised 2 interesting points. The first one, though, you always have a duty to assess your client's ability to assist in their own defense. And there are situations where your client was fine, and then, they get an axe in their head, and then they're not fine. And so you need to assess it at every hearing. However, and I think people do that. Obviously, if your client shows up one day and is totally able to assist you in the defense, then that's obvious to you. What's less obvious is that everyone here who is a guardian ad litem and everyone here who is a lawyer for a client with guardian ad litem, at every hearing you need to be assessing whether that guardian ad litem is still needed. Mental health is a changeable thing. It's very, very fluid. And as I was pointing out before, getting back on their meds after a couple of weeks off may do the trick in getting the client back on track with you. Also, it may turn out that the whole thing was just an act. And once they realize the effects of the act, that they've now lost their voice in the case, they may show up at the next hearing and they may do better. Also, family members may have gotten through to them and been able to explain to them enough that they can now be cooperative. And then you have a duty to go into the court, and the very first thing out of your mouth will be that, well, if you're the guardian ad litem, you have to tell the lawyer, and then the very first words out of the lawyer's mouth were, first, Your Honor, I'm making a motion to have the guardian ad litem relieved.
I think that maybe to answer your question about whether or not you have a duty to seek a GAL,
that was the first question.
If we carry on with the rest of our policy, essentially the ultimate conclusion is that we should never be seeking GALs for our client's absent consent. And we have a couple of alternative options to what you do if you cannot obtain a client's consent, but you're in a situation where you really think they need a GAL. So I don't know if
Yeah. So, yes.
If your client is under a conservatorship, should you automatically seek a GAL?
no.
No, because the conservatorship may just be for issues of money. That person's not capable of handling their money, but they're totally capable of understanding that you know, DCFS has taken their child and they want their child home, or they want their child back with their sister.
No, I'm
So
talking
you've got-
about like a mental health conservatorship.
Well, they're all, I mean, that's what a conservatorship would be, but they're all for different reasons. So no, you still have the obligation of making your own assessment of your client, your ability to have as close to normal as possible of an attorney-client relationship. But also with a conserved client, you have to be talking to the conservator if it's a conservator for the person. You can't be proceeding with the client. You would just tell the judge, my client has a conservator of the person, and therefore that person should be here, or they need to waive it. One of those two. So going on to consent. The preliminary to consent is explaining to your client what a guardian ad litem is. Can anyone throw out a one-sentence description that would describe what a guardian ad litem is?
Another attorney.
Exactly, and that is exactly, thank you. I was like, I planted her, because that is the one thing the judges say most often, and it's a lie. It is not two attorneys for the price of one. It is not, you can have another attorney whose job is just to explain things to you. No, all of this misses the point that what is going on is that you are not going to be in charge of your case anymore. This guardian ad litem is going to make all the decisions for you. Their voice is being silenced, literally. Once you've explained to them what a guardian ad litem really is, then you can ask them if they consent to that, if that's what they would like to have happen. And you'd be surprised. There are still clients who, while suffering from severe mental illness, do absolutely understand that they're not capable of doing certain things, and that the maelstrom of dependency court is way beyond them, and they would gladly give it up to a guardian ad litem. Now, that's when we have to look at, well, excuse me, then we go on to consent and obtaining consent, and I think that Jessica has some information on that. Thank you. Oh, okay. Sorry. Okay, so
obtaining consent, I'll just briefly tell, and then we'll move on to the rest of the policy. But I think Dennis already kind of covered it. You have to obtain informed consent. It's not just asking your client who appears to be somewhat diminished in their capacity, like, hey, so are you okay with somebody making decisions for you? You got to make sure that they understand exactly what that entails, what that means. So it's not just saying to them what a guardian ad litem is. It's also what authority would a guardian ad litem have? What decision-making power are they going to have? The client needs to understand that means they will be the ones who will be determining whether or not to settle your case. They will be the ones who are determining, what witnesses should or should not be, with input from the client. The client always still maintains the right to give input. They just lose the decision-making authority in a case. So ideally, you're still communicating with the client, and they're telling you their story about whatever their story may be about their case, and the guardian ad litem is then making the investigation and determination about, okay, so do we need to subpoena this federal FBI agent into court to testify about what's going on here, or are we cool with not doing that? Yes?
So informed consent, something that Dennis had said before, a question. Do we know anybody who's been able to get their child back with the GAL? So is that part of informed consent in telling them that, oh, by the way, everyone who's ever had a JL doesn't get their kids back? I don't think the answer would be, I want a JL.
Right, I'm not sure that, we can say that perhaps, to our personal knowledge, nobody who has had a JL and they've been able to get their kids back. I don't know that we can say to them directly that, I don't know anybody who's had a JL who's been able to get their kids back, but part of determining it is, number one, what is a JL? Number two, what authority they will have? And number three, what are the consequences of having a JL? And the potential consequences are, yes, that it may make it more difficult for you to get your children or child back in this case, because the underlying assumption, even though this is not what it's supposed to be, the underlying assumption when a guardian ad litem is appointed is that you are unable to make competent decisions on your own behalf. So that definitely calls into question a parent's ability to make parenting decisions or child rearing decisions on their child's behalf, including, in some of these cases, the ability to make an appropriate plan You may have a client who is having diminished capacity, but does not need a GAL. They have relatives and family members who are available, and they should retain the ability to make that decision over making an appropriate plan to have somebody else assist them to care for their child.
Ms.
Question?
Ruth?
So under Sarah D, what you're saying is there's two ways to become a guardian ad litem, either through the informed consent of the client or through the court's inquiry. The problem with the court's inquiry is you're telling us to limit it. We have to really make sure there's absolutely an issue of competence and it shouldn't be for an irascible client. But on the other hand, isn't it better to go that way because at least it's on the record rather than having the discussion with the client and then going before the court and saying, I have informed consent? It would seem to me that we as the lawyers would rather than just talking to the client about it and then the client saying, yeah, I understand everything. And I mean, if the client can say that to you, I don't even know how you can get informed consent from a truly incapacitated client. Well, it would seem to me that as much as we're trying to limit it, that it's better than we go through the court because at least there's a record of the questioning and how the client answers, and in many ways it protects the attorney. Because if you really have a client who lacks capacity, it's obvious on the record.
The problem is that it is always a hostile act towards our client.
Of course it is.
And if we're already their attorney, we can't take that hostile act. Now, the majority of these cases will arise at detention or at first appointment. And that's a little bit different because you're not yet the attorney for the client. And so you can go into the courtroom and say, Your Honor, I can't form an attorney-client relationship with this client. Perhaps the court would like to inquire from the client. And that's definitely something you can do. But once you are the lawyer, if you choose at that point to try to pursue a guardian ad litem, you have to tread very, very lightly because it is an aggressive act against your client's best interest. Yes.
So, I mean, as far as...
Can I just piggyback really quickly? Okay, so as far as this whole idea, I understand it creates sort of like yeah, like people don't understand how can a person be incompetent but then consent to something. But let's just think of, so James F. is the only Supreme Court case in California that discusses this issue. Ultimately, that case decided on a harmless error standard. But in that case, the court decided that, I don't remember the father's name, I don't think it was James, because that was the child, but the father in that case, who was the issue, appealing the issue of the guardian ad litem, would have probably consented in the end, because in this case, he was incarcerated, he was out patent for a long time, he at one point was conserved, and then no longer conserved. He started waiving his appearances to appear in the proceedings. He wanted his child to stay with the parent, the grandparents, I think, maternal grandparents possibly. He did not want to participate in this decision-making, and he was of limited ability in any case to be present, be providing substantive information to the court, and limited ability to assist in his defense. The court in that case decided that he very may well have consented to a GAL, and they found it was harmless error. I envision that there will be very, very, very rare circumstances in which you're able to obtain a client's consent for a GAL if we're adequately informing them of the decision that should be had. But likewise, that means that there should also be very, very rare circumstances when we're actually getting GALs in some cases, because what we're trying to communicate to everyone here is that
comas.
Right. There's going to be cases where you have a client who absolutely everybody can agree is unable to make decisions on their behalf.
Axe in the brain.
Anyone?
Yeah, I do. I like it.
Oh. So those are the cases in which you're hoping to somehow, without divulging any client confidences and without requesting anything to the court on your own, so coma patient, you already represent him or her. They fall into a coma mid-representation. You appear at the hearing and you say to the court, I'm unable to communicate with my client, Your Honor, and I'm unable to proceed at this point. You may need to be seeking to get withdrawn at that point. It depends on the circumstances. I'm not saying coma patient you're seeking to be withdrawn, but in some of these circumstances you're seeking to withdraw because of your conflict in your duties. These are little indicators to the court that they should be conducting a GAL inquiry. I don't know any bench officer who wouldn't see a coma patient and you say, I'm unable to communicate with this client, Your Honor, and they don't on their own think that a GAL is probably appropriate to be appointed for somebody who has fallen into a coma mid-case during these proceedings.
And just to clarify, so now take that exact same situation, but it's at the detention. Well, then you just go into the court and you say, I can't form an attorney-client relationship. You've got to be real clear on this process, the order. So what the court needs to do is first appoint a guardian ad litem. Then the guardian, once the guardian ad litem is appointed, the guardian ad litem forms the attorney-client relationship with you. Okay? Chris Jackson.
They're not technically your client, you still owe the duty to the actual client, but the guardian ad litem is the representative for the client.
Chris?
So, I think most of the times we're talking about a client with mental health issues, but what about in the rare instances where the issue comes up because, say, our client or our potential client or our client is definitely minor, say like 12, 13, 14, as gross as that is, I'm sure it happens.
So there's case law, it used to be automatic appointment of a JL for a minor parent because of an assumption of minor incompetency, but there's case law, actually on point, I should have pulled that case, but that has been, and statutory authority, which has since rebutted that in accordance with the case law, that there is no assumption that you go through the exact same analysis you go through with an adult.
This rule of professional conduct doesn't apply.
Just because they're a child doesn't mean they're unable to make decisions and adequately assist you with their representation. If they're a child with a child, I sure hope that they kind of have the ability to make some decisions and assist you in their case. It's not an automatic thing. You gotta assess it as you would with any other case. So if there are some other circumstances with that minor parent, maybe they're a regional center client and you need to assess why are they a regional center client, what are the circumstances of their disability, or they have mental health issues, you're assessing again, what are the circumstances of their mental health condition? Is this something that, are they in a hospital incapacitated, or are they just like a large number of our mentally ill clients that we get almost every day, where they have some delusional and bizarre thoughts, but ultimately they can say to you, I want my child back, I didn't do this, and I don't want them in that foster home, or I want them with my sister, or they can provide you with direction. You can represent them without a GAL.
And that leads me to how do you kind of back into that quagmire of you're sitting across the table from this client and do they need a GAL or do they not? I would propose that none of you in the course of a normal workday are able to devote the time that is necessary to arriving at a conclusion to that question that moment. So I think that you should all be calling your supervisors, getting your supervisor or your floater over there, maybe even just another lawyer who's free, but someone else needs to be putting in the time that's necessary to really get to the bottom of what's going on with your client. Dan?
I'm jumping around a little bit.
Sure.
On my informed consent, and the case law regarding that, I'm just looking at CRD, it says, this is the third paragraph, the attorney must then either approach the client and request consent or approach the court directly. It seems to say either or. Is our legal policy going to be go to client first to try to obtain consent, and then the court?
Our legal policy is getting rid of any going to the court as the attorney.
To be clear, our LADO policy is incorporating the proposed rule of professional conduct, 1.14, and it has been proceeding steadily, and I expect that it will be adopted by the California Supreme Court within the next year or so, but that's what we want you to comply with, the very highest standard. Yes, Jennifer?
I just wanted to make sure I heard you correctly. Did you just say that as ladle attorneys, we are no longer allowed to go to the court once we're the attorney and ask for JL inquiry?
I am saying, yes, this is the radical proposal that we are making at this training, that getting a guardian ad litem appointed for your client is a hostile act against your client that virtually ensures they will never get their child back, and therefore is not something we should be doing except in extremely rare cases.
And perhaps if I can address that even further after we finish, Dennis, we'll continue with the, get to the end of the, we talk about this. But there are a number of steps we talk about in between to try and alleviate the situation where you feel like you would normally, as of right now, go to the court and say, I think my client needs a GAL, the court should conduct an inquiry. We have a number of steps that you need to go through before you get to that point, well, that point never occurring in this circumstance.
Number one being, maybe it needs to be another lawyer. Maybe it needs to be another firm. You know, if you're, especially if you're at detention. If you can't do this, it's okay. It's not, you know, if you find yourself way in over your head, consider the idea of having somebody else do it. Call your supervisor, be honest with your supervisor. Maybe they'll take it over. Maybe you'll make an agreement that some other ladle can accept appointment on that case. There are a lot of options that are available to you. That's one possibility. Yes.
When the question is asked, do you mind? You
No,
guys
just
are-
shout it out. Yeah.
Oh,
repeat
the
it,
question.
they want to hear the base question.
Oh, I will. Yes. Sorry. And then second, you can consult. That was what we were talking about when we said, you know, get a continuance. Send the client away to get back on their meds, for the family to work with them. You know, they could be having, and probably are if you think about it, you can pretty much assume that all of our clients are having among the worst days of their lives in that courthouse with us. And we're supposed to be their shepherd through it, not somebody else who's going to fire another bullet into their leg. And then finally, if you are unable to form the lawyer-client relationship, you just go in and you say, I can't form an attorney-client relationship with this client. And the court will inquire. The court will, you know, call the client in or, you know, ask someone else to go out and, you know, they'll proceed. And the judge may well order a guardian ad litem on their own motion. Unfortunately, anybody can ask for a guardian ad litem hearing. It could be another counsel. I have one case where county counsel is asking for the guardian ad litem. Pissed me off no end, but you know, getting pissed off doesn't help. I have to go to the law, I have to find the law, and I have to brief the issue and have the hearing. You know, hopefully we'll be able to resist having a guardian ad litem appointed for our client because it's the social worker who's not able to communicate with our client. Our ladle attorney has put in the time and the effort necessary, we call it the Groundhog Day case, because the client has a medical condition where they have no short-term memory. But the client, the attorney, each time talks to the client and goes back through the whole case, goes back through the whole history, and gets them to make their decisions. And each time, the client makes the exact same decision, and the client lives with family members, and all the family members also support the fact that this is exactly what the client wants and what is in fact best for the client and the children. And so there is no need. We have made, this attorney has made as close to possible, as close a normal attorney-client relationship as possible. And they should proceed, and county counsel should not be butting in and trying to mess with the attorney-client relationship because their social workers don't want to put in the same amount of effort.
And in those rare circumstances that we hope are very rare circumstances where we talked about considering those special efforts, you're appointed as counsel already on a case and your client becomes incompetent or has some sort of diminished capacity in your opinion. Nobody's caught on to this yet, just you and your communication